attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transaction law firm. Today is the first Lawcast in a series discussing SEC disclosure requirements. The topic of disclosure requirements under the federal securities laws, and in particular the requirements under Regulation SK, have come to the forefront over the past couple of years and have been a regular topic of industry discussion, recommendations, and review. On April 15, 2016, the SEC issued a 341-page concept release and request for public comment on sweeping changes to certain business and financial disclosure requirements in Regulation SK. Prior to that, in September 2015, the SEC Advisory Committee on Small and Emerging Companies met and finalized its recommendations to the SEC regarding changes to the disclosure requirements for smaller publicly traded companies. Prior to that, in March 2015, the American Bar Association submitted its second comment letter to the SEC, making recommendations for changes to Regulation SK. In early December 2014, the House passed the Disclosure Modernization and Simplification Act, following which it was bundled into the FAST Act and passed into law on December 4, 2015. The disclosure modernization provisions, as included in the FAST Act, require the SEC to adopt or amend rules to allow issuers to include a summary page to Form 10-K and to scale or eliminate duplicative, antiquated, or unnecessary requirements for emerging growth companies, accelerated filers, smaller reporting companies, and other smaller issuers in Regulation SK. In addition, the SEC is required to conduct a study within 1 year on all Regulation SK disclosure requirements to determine how best to amend and modernize the rules to reduce costs and burdens while still providing all material information. The FAST Act gave the SEC a 180-day deadline to issue rules and regulations implementing changes. The FAST Act requests that the SEC emphasize a company-by-company approach that allows relevant and material information to be disseminated to investors without boilerplate language or static requirements while preserving completeness and comparability of information across different companies, and evaluate methods of information delivery and presentation and explore methods for discouraging repetition and the disclosure of immaterial information. This approach is thought to have as a principled approach with a concentration on materiality as opposed to just filling in line item information whether relevant or not to that particular company. It is believed, and I completely agree, that simply providing required line item disclosures that are not relevant to a particular company dilutes the material information regarding that particular company and has the unintended consequence of weakening necessary disclosure to potential investors in the public trading markets. Even before the FAST Act, in May 2015, General Electric filed its annual 10-K with a complete makeover from prior years. GE's 10-K, the first like it, is full of colorful charts and graphics and has scaled down narrative from what was once a virtually incomprehensible document. GE worked with the SEC on the new 10-K utilizing the materiality approach. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of Lawcast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.